against humanity. There is a lot of information to cover in this presentation, so the pace will be rather quick. I apologise in advance for any mispronunciation of names. To do this, I will be looking at 6 key points. We begin with a quick summary of the history of how rape was viewed in wartime. Acts of rape committed in war have long been considered simply unfortunate consequences. Alongside loot, rape was considered part of the spoils of war. One only has to consider how commonplace and innocuous the phrase rape and pillage is to appreciate this historical connection. So how did our understanding of war rape change from an unfortunate consequence of war to a punishable method of war? Our understanding of war rape has changed dramatically since the Nuremberg and Tokyo trials, from a consequence to a method of war. And this change in understanding led to the development of rape as a crime against humanity. Before we move on to how rape is prosecuted, it is best that we understand how and why this change occurred. Since 1945, the nature of war has changed significantly. Wars are fought less and less on neat front lines and are more often fought within civilian areas between nationalistic paramilitaries or ethnic militias. In these new intrastate wars, ethnic cleansing is often the goal, and as such, rape has become a military strategy, a nationalistic policy, and an expression of ethnic group hatred. This form of sexual violence is being intentionally inflicted on civilian women as a tool for humiliation, degradation, forced impregnation, and ethnic cleansing. In short, the penis became a weapon of war. 2 significant factors contributed to the change in thinking of rape as a method of warfare. They were the role of NGOs in cooperation with the media and the evocative testimonies of victimized women. The sheer scale and viciousness of sexual violence against women in Yugoslavia and Rwanda drew increasing media and NGO attention. Easy access to world radio and television made these atrocities internationally visible. This meant that public outcries for peace and justice were swift and loud enough to force governments and the Security Council to act. In addition, the testimonies of individual women were invaluable to the process of rape becoming a crime against humanity. The media gave these women an avenue in which to tell their stories and appeal for justice. The moving documentary I Came to Testify points out that these brave women who testified risked extreme danger because everyone in the women's village knew who was testifying. We now move on to examine 3 important organisations involved in the prosecution of rape. The multiple wars in the former Yugoslavia lasted for nearly a decade. All the wars combined resulted in the deaths of an estimated 130 to 140,000 people. In the Bosnian conflict alone, an estimated 40,000 women were raped. The cruelty shown by armed factions towards civilians, the blatant disregard for the rules of war, and the widespread use of rape as a weapon of war, combined with the pressure and publicity caused by NGO and media reports, forced the UN Security Council to approve Resolution 827 on the 25th of May 1993. Under Chapter 7 of the Charter of the UN, the UNSC decided to establish an international tribunal for the sole purpose of prosecuting persons responsible for serious violations of international humanitarian law. This tribunal came to be known as the International Criminal Tribunal for the former Yugoslavia. Under Article 5 of the ICTY statute, the tribunal was given the power to prosecute persons responsible for crimes against humanity. When committed in armed conflict, whether international or internal in character, and directed against any civilian population. What was so groundbreaking about this article was that it was the first time an international tribunal had included rape as a crime against humanity. The most notable case of the ICTY was that of the prosecutor versus Kunarak, Kovac and Vukovic, aka the Kunarak case. This case centered around allegations that Muslim women in the Foča region were subjected to a brutal regime of gang rape, torture and enslavement by the accused after the takeover of the city in April 1992. The tribunal charged 3 primary defendants and 5 others with crimes against humanity, grave breaches of the Geneva Convention, and violations of the laws or customs of war. On the 22nd of February 2001, 5 years after the indictment, the defendants were convicted of the crimes and sentenced to prison terms ranging from 11 to 28 years. What was so important about this case was that it expanded the concept of crime against humanity to include rape and sexual violence, was the first convictions of rape as a crime against humanity, was the first convictions of enslavement as crimes against humanity. It gave a clear definition of rape as a crime against humanity in terms of conventional legal categories, and it issued a strong warning to future combatants that lawless opportunists should expect no mercy, no matter how low their position in the chain of command may be. Some other important successes to come from the ICTY were the Celebisi case, which concluded that rape could be seen as a grave breach of the Geneva Convention, Additional Protocol 1, that refers to torture or inhumane treatment, and the Furanzija case also concluded that rape could amount to torture under the Geneva Convention. We now see how rape as a crime against humanity was prosecuted in Rwanda. From the 6th of April until mid-July 1994, a genocidal mass slaughter of the Tutsi ethnic group by the Hutus took place in Rwanda. Just like in the Yugoslav conflict, rape was used as a weapon of war by combatants, chief perpetrators being the Rwandan Defence Force and the Interahamwe, a paramilitary Hutu organisation. The UN Special Rapporteur in Rwanda calculated that at least 250,000 and possibly up to 500,000 women, mostly Tutsis, were raped during the 100 days of genocide. There is also preliminary evidence that Hutu militias specifically recruited HIV-infected men. These men reportedly told their victims before raping them, "We are not killing you, we are giving you something worse. You will die a slow death." After sustained pressure from human rights NGOs and the international media, the UNSC responded to the crisis with Resolution 955, which established another international tribunal similar to the ICTY, the International Criminal Tribunal for Rwanda. The ICTR borrowed the definition of rape as a crime against humanity from the ICTY and subsequently expanded the scope of said definition through their most renowned case, the prosecuted versus Jean-Paul Akayesu. Jean-Paul Akayesu was the mayor of the Taba commune in Rwanda during the genocide. Rather than preventing the atrocities from occurring in his district, the prosecution alleged that he personally oversaw the rape and murder of thousands of local Tutsis. The defendant was charged by the ICTR with 15 counts of genocide, violations of the Geneva Convention, and crimes against humanity. Despite his defense that he was merely a scapegoat for the crimes of the people of Taba, on the 2nd of September 1998, Akayesu was found guilty of 9 counts of genocide and crimes against humanity. This case was crucially important for the prosecution of rape for a number of reasons. Firstly, the judgment against Akayesu was the first recognition of sexual violence and rape as being fundamental to the genocide in Rwanda. Secondly, the ICTR found that rape can be prosecuted as either a distinct crime against humanity or as an act of genocide. Thirdly, the ICTR refined the definition of the crime of rape by emphasizing the importance of coercion. As Navi Pillay, the current High Commissioner for Human Rights at the UN and former president of the ICTR, stated, "From time immemorial, rape has been regarded as spoils of war. Now it will be considered a war crime. We want to send out a strong signal that rape is no longer a trophy of war." Another successful conviction of rape as a crime against humanity was that of Silvestre Gacumbitsi. The defendant was charged with luring Tutsi women to a certain location. When a number of women gathered in response to his exhortations, they were surrounded by several attackers, raped and then killed. Although the accused was successfully found guilty of rape as a crime against humanity, the dismissal of the charge of complicity in genocide related to rape showed that proving genocidal intent can be quite difficult in cases of war rape. The final organisation to be analysed today is the International Criminal Court. Following on the heels of the prosecutorial successes of the ICTY and ICTR, on the 17th of July 1998, members of the international community adopted the Rome Statute of the International Criminal Court. 4 years later, on the 1st of July 2002, the statute came into force, thereby creating the ICC. The key task of the ICC is to investigate and prosecute 4 fundamental international crimes: genocide, crimes against humanity, war crimes, and the crime of aggression. The ICC can only carry out this function if states are unable or unwilling to do the task themselves, if the crimes are committed in the territory of a state party to the statute or by a citizen of said state, or if a case is referred to the ICC by the Security Council. Under Article 7 of the statute, the ICC can investigate and prosecute crimes against humanity. One of these numerous crimes is sexual violence and rape. To overcome any problems associated with what constitutes an act of rape, the ICC created a comprehensive definition encompassing case law from both the ICTY and ICTR. Finally, the ICC is not restricted to investigating crimes associated with armed conflict. It can prosecute any acts when committed as part of a widespread or systematic attack directed against a civilian population. One current example of the ICC in action prosecuting rape as a crime against humanity is the Jean-Pierre Bemba Gombo case. This prominent case is related to the current conflict in the Democratic Republic of Congo and its spillover effect into neighbouring countries. The accused is former Vice President of the DRC and is the leader of the Movement for the Liberation of Congo, or MLC, a Congolese political party that emerged from a militia group of the same name. In 2002, the President of the Central African Republic invited the MLC to enter his country to suppress a coup attempt. Human rights activists accused MLC fighters of committing atrocities against civilians in the course of this conflict. The prosecutor alleges that under Bemba's command, women were raped on the pretext that they were rebel sympathisers. Men were also raped as a deliberate tactic to humiliate civilian men and demonstrate their powerlessness to protect their families. In May 2008, Bemba was arrested in Belgium on an ICC warrant related to these atrocities. The ICC has charged him with 2 counts of crimes against humanity under Article 7 of the Rome Statute, namely rape and murder. The trial of Bemba began on the 22nd of November 2010. The final part of today's presentation will be 2 suggestions that I believe will strengthen and further legitimise the prosecution of rape as a crime against humanity. Firstly, no one person should be above the law, especially when it comes to rape. Yet United Nations peacekeepers have often been accused of heinous sexual crimes, which could easily be characterised as crimes against humanity. Currently, there are nearly 75,000 UN peacekeepers operating around the world. Contributing nations maintain exclusive jurisdiction over their military troops, which means that neither the United Nations nor the host country can take legal action against soldiers. In recent years, there have been accusations that UN peacekeepers have committed sexual abuse, such as child rape and gang rape, in the DRC, Haiti, Liberia, Sudan, Burundi, and Côte d'Ivoire. In effect, UN peacekeepers have gotten away with committing rape in areas of conflict, which would have fallen under the category of crimes against humanity. As frontline representatives of the international community, these men and women must be held to a higher standard and behave in ways that strengthen the reputation of the UN. This has most certainly not been the case. Finally, I believe the best way to further the prosecutorial successes of the past is to increase the number of signatories to the Rome Statute. On the map, you can see the dark green countries have signed up to and have ratified the Rome Statute. The light green states have ratified the statute, but it is not yet in force, and orange indicates the countries have neither signed but not yet ratified. Grey countries, have neither signed nor ratified the statute. Importantly, the countries with the 5 largest militaries in the world, Russia, China, the USA, North Korea, and India, have refused to come aboard. The premise here is simple. The more states that are bound by the Rome Statute, the less chances there are that those guilty of committing rape as a crime against humanity will be able to escape justice. That's all for today. I apologise again for the density of the information and any pronunciation issues during the presentation. For additional information or reading, please consult the references section at the end of the attached PowerPoint file. Thanks again for listening, and goodbye for now.